Okay, in the first panel, I was very excited because it was the beginning of the conference. Now I'm very excited because it is the end of the conference. I'm also excited because I realize that I'm moderating a panel with giants in the legal profession. You probably, as you know, yes, we've seen already, and we heard two wonderful keynotes, one by Professor Coffey and the other one today by Professor Issakarov. Now we are joined by another superpower, Professor Hans Miklitz from the European University Institute and co-partner in the organization of this event. I know you probably imagine that now Ingrid Gube will come in, but no, this is the real Hans Miklitz, and Ingrid has agreed to replace him in two earlier panels. What we would like to do now is to pose one question to all the members of this panel. And the question is, what is the future of collective redress to your mind? And especially, would you relate to cross-border transactions? Can the law assist in bringing the confidence we need in international trade? And the first panelist will be the Hans Miklitz, who will give the European point of view, and then we will get reactions from his fellows from the United States. Please, Professor Miklitz.
Okay, that was a bit too much, Aaron, but thank you nevertheless. Okay, so yesterday, unfortunately, I came late because my flight was cancelled in Florence, and I was not ready to arrive here at 5 o'clock in the morning, so please apologize. So I could not listen to Jack Coffey, but I could listen to Sam speak, and let me start with this. That was a wonderful speech. It was convincing, it was colored with humor, and it had a clear message. Let's look at us. Here, we made it. So, and I was wondering if there would have been here, if Sam would give the same talk in a European audience, sitting all the politicians, the legislators, the parliamentarians, the academics, the lawyers, and so on. And they would lean back and they would say, "We are so happy that we are not in the United States." You know? So, and then there is also another story. That's more or less the story of my lifetime. When I was a young scholar, the US class action was still in its infancy, and it was praised when the consumer movement swept over to Europe. It was praised as the magic tool. US class action, that's what we should have. So that's roughly 30 to 40 years old. And I think if we look into what has happened during these 30, 40 years in the field of what the Americans call class action, we have not made much progress. We have not made much progress in Europe. It's a painful process, and when the Americans look at Europe, they usually understand Europe as a homogeneous body, which is certainly not the case. We have not only still up until today 28 countries, we might still have 27, we have 22 languages, we have more legal orders than any comparative lawyer can handle. We have the procedural differences, and it's a mess. It's a mess. So I'm wondering whether the future is not elsewhere. And let me give you a typical European perspective on this. I would have preferred, by the way, to speak last, but so old Europe should speak last. But Nevertheless, let me draw your attention to two pieces of law against the background of what James Whitman calls the differences between the producerism and the consumerism. I think there are deep cultural differences between whatever you call Europe and the United States, and if I look back to the last 30, 40 years, I'm not so convinced that Kieleman is right in his idea that we are moving towards Euro-legalism also in Europe. I'm not so sure. I think these deep cultural differences that Whitman describes are still very valid. So let me draw your attention to two pieces of law that are typically European to my mind and that might provide the potential for a different avenue, in particular with the digital age and the artificial intelligence. The first one is the Unfair Terms Directive. It's from 1993, and it has reached also now the United States. If you read the draft proposal of the American Law Institute on consumer contracts, as a European lawyer, you feel very much at home because that looks like like a piece of EU law, yeah, with a general clause and with all the different means. So I think even to the Americans that whether it's right or wrong is another story. There's a lot of debate. Officially, I'm not allowed to read it, but as you may imagine, it's all accessible nowadays. So that's one point. The Unfair Terms Directive means the deep tradition in Europe on prohibiting certain misleading practices. And the other one is now the Data Protection Regulation, the data privacy. And what we did with a small crew of academics in Florence, and Florence is important here because the European University Institute is in Italy, but it's not an Italian institution, it's a European institution. So we are, let's say, in a way freed from a national perspective, and we can look across the borders. So we took these two pieces of law, and together with computer scientists, we asked the question, is it possible to automatically detect unfair contract terms or data privacy policies that are illegal, and to build knowledge about this and later on strategies. So we are on a small scale budget because, as you know, nobody is financing this, in particular when you say loudly what you want to do, because I think it has been nicely put in the previous session, consumer law in Europe was not meant to be enforced. Yeah? I think it's symbolic law. Don't take it too seriously. And in particular, also, do not make money out of it. I just repeat it because that was said before, but maybe not everybody was present. So there's a deep difference. And I think what's now possible with these two pieces of laws, European laws, that set European standards, that these standards can be transformed with a software into an automated system of detecting where potentially misleading, unfair contracts or data privacy policies are. So the first thing was to build up a database. What we have been doing, I think we are quite good in the field of unfair terms. We have more than 100 contracts that we have screened and tagged from the big data suppliers, and we will do the same in the data privacy policies with regard to data privacy policy. And here we will hopefully cooperate with NYU, with Florencia Vogler, who has collected a big stock of data. That's also very interesting. We want to merge the data so that we can then jointly analyze them. And we all know it's painful. I will not bother you with details. Everybody who has been involved in this tagging exercise and this going back and forth, that's painful. But in the end, we are making progress. And we have two steps that I would like to mention that we are currently working on. The one is not only to say that a particular strategy or whatever is potentially unlawful, but to link reasons to it. We are building on this legal reasons and legal reasoning so that we have not only an indication but also arguments why this term can be potentially illegal. And the other one is, which is a big topic in Europe, but it's not one in the United States, it's language. Yeah? Let us not forget, in Europe we have 22 languages, or whatever you want. We can also add a couple of them. And it's extremely important because the data privacy policies or all this what's going on is in the national language. So what we need is a tool that is able and that can translate knowledge from one language to the other. So that's the second problem we are working on. And the last thing that is also what we like to do is to develop a web crawler that is constantly checking on a daily basis what these amendments are, that we automated the reporting so that we know exactly when the company has changed its policy. And we will also try to use this to make it usable for particular sectors. So it means currently we are looking into service providers, but then that you can look into energy or telecom companies or whatever, so that you can identify. This is a first step. We know we have more ambitious goals, but I think it's and that's my conclusion. It's very European in the way that you look forward, so much more in the future to prevent something in order, whereas the whole conference was on, as I suppose, on compensation, where Europe is potentially weak. And when you see the recent developments, I was just listening to the last session, I think there is just the opposite of what Sam said in the morning in Europe. There is resistance in the courts to accept such a role. And that's true for the European Court of Justice. Think of the Facebook case. That's true for the German courts, or for the French courts, or for the Dutch courts. Or there is no willingness to take over this role. And I think that the internet and the artificial intelligence and whatever offers new strategies for the consumer society, or for the society as large, to build totally different mechanisms and tools that are not entirely built on the law alone, although I will not deny that the law has certainly an important role to play. But I'm not so optimistic that in Europe we will get this nice photo that I think Sam showed us. Yeah? I think we are far away from this, and Germany, it's pretty clear why Germany is not willing to sue Volkswagen. That's protect its industry, I think. Okay, that's my closing remark. Thank you very much.
All right, so Hans asks if I would give the same talk in Europe. Hans, I've given it on your invitation in Europe, so
but not with the politicians and the judges and
lawmakers. Invite me, and you will see to my mother's chagrin that I'm not well disciplined, and so I will do it there also. But Hans raises a critical point. There's a huge cultural difference between countries that come out of the civil law tradition, where there's a belief in state authority, and countries that come out of the common law tradition, where there is much more resistance to the role of the state. The United States is not a panacea. It is the same process of distrust of state centralization that gives us class actions and private initiative. It's also the same process that gives us the Second Amendment and every lunatic in the world carrying a gun. So it's a mixed bag, and you have a lot of cultural baggage there. But I think that the main divide is still on the question of, do you want private enforcement? I mean, every discussion I have in Europe always comes down to that question. Do you want private enforcement? So let me give you an example. I'm on the Council of the American Law Institute, and we helped set up the European Law Institute. So a few years ago with Astrid, I was at a meeting in Vienna, I think it was, and there was a discussion on the first draft presented by the European Law Institute on collective redress for consumer claims. Point number one was no lawyer may make any money out of representing. And so I came all the way from New York and I said, I'm done. I don't need to hear point number 2 and 3 and 4 because I already know everything I need to know. You don't want this enforced. So what difference does it make what you're going to write after this? Now, that's all true. We start from very different cultural premises. On the other hand, one of the points I hoped to get across this morning was we didn't go from 1966 to VW and British Petroleum and the NFL concussion case just directly. It wasn't legislated. It wasn't in our DNA that that's automatically what we do. You had to learn, and you had to learn because we unleashed lawyer incentives to do this, and the courts learned how to handle this, and it was a process of transformation. Now, I think the question for Europe is what happens if you don't allow mechanisms of reasonable private enforcement? What happens if European consumers see what happens in the United States with Volkswagen and know that the damage in Europe was much greater and that you're getting no compensation, you're not getting your cars fixed, you're not getting pollution out of the system? What's going to happen then? Well, it's not clear to me that what's going to happen is purely within the regulatory domain, because there are entrepreneurial initiatives that are available in Europe also. Maria Jose was telling me that in France, the main operational force for collective redress now is something called platforms. Platforms are finance vehicles that allow people to sign up online for small value claims or larger value claims, to have them prosecuted collectively by an entrepreneur who then hires the lawyer. Sometimes it is the lawyer. And if you go back, this is what happened in Australia. Australia used to have no class actions whatsoever, despite extremely favorable class certification rules. Why? Because the cost structure was prohibitive, because you couldn't have contingency fees, so the mechanisms for lawyer initiative were not there. What happened? The market responded, private initiative responded, and so you got litigation funders. They filled the void where the state couldn't police certain kinds of improprieties and where the formal rules of procedure didn't allow for it. The way they filled it was they would aggregate the cases, they would finance the cases, they would insure against adverse costs, and they would take 30, 40, sometimes more percent from each person they signed up. So much higher transaction costs than our class actions in the United States. They filled a void, and as we heard yesterday, the relative cost is coming down because now you have competition. It's a much thicker market than it used to be. And those same Australian entrepreneurs then attacked England, right? Because, you know, it's only fair. You send all your prisoners to one country, and they're going to come back as a band, you know, and they're going to take you on. And so they attacked England, and it turns out the continent was vulnerable also. And so you're seeing entrepreneurial spirit that comes along. I still think that Volkswagen is a challenge to the Europeans in a kind of deep existential way. How could you let a harm perpetrated around the world on the same basis by a German company where the locus of the harm is most centrally felt in Europe and allow that company to pay compensation for what it did only in the United States? It seems to me that Volkswagen is what you all have to answer for in Europe. I don't think this is the worst crime ever committed by a company or anything of the sort, but I think it's a challenge that there was a sense of having to account for it and having to remediate in the United States and not in Europe for all the regulatory structure of Europe. I think that is, you know, you may decide that it's a price worth paying. You may decide that, you know, okay, so we'll deal with it in the future. We'll have greater regulations, more accountability through the regulatory process. You may decide that, but in the meantime, you have a lot of frustrated consumers in Europe who think they've gotten a bad deal and that the Americans got something out of it and the Europeans did not. So I don't want to preach the American way of doing things. All I want to say is that the American way of doing things didn't start off the American way of doing things. It evolved out of certain kinds of institutional actors, entrepreneurial initiatives, and you start to see those developing in Europe, and I'm not sure that everything is going to stay confined within the regulatory domain.
As I understand it, the question was asked, what's the future going to look like? And the answer Hans gave is, Europe is not going to follow the United States, and the United States is not the future. There's a tunnel vision both
Not the
there.
European future.
Just a second. I'm talking about the world's future. And there's a country called China and there's a continent called Asia that you're ignoring, and that may be where the most important developments are coming. If we look at where class actions have recently had major changes, the two countries where class actions have really taken off in the last 10 years are Canada and Australia. And it did involve the creation of new substitute institutions. You can have contingent fees in Canada. You have fee shifting in both countries, very little in Canada actually, and you can have litigation funding, as Sam said, replace the contingent fee. So you've seen Canada and Australia have sharp increase. Now, I also believe culture counts, and I note this. South Korea, when it had a financial crisis, decided that it was going to initiate American-style opt-out class actions, the full thing, full-bore opt-out class actions. What happened? Nothing happened. Japan did the same thing. Very little happened. It's the culture. Companies don't like to sue other companies in those countries. It's not appropriate. That's the culture. All right, and we don't have individual shareholders the way we have in the United States. We have large corporate groups. They don't want to sue each other. So little changed immediately. Now this fall, I was visited at Columbia by the head of the Chinese SEC. They note they have real bubbles and real problems with enforcement, and the government is not adequate to it. So they were trying to come up with a proposal to legitimize opt-out full-scale class actions in China. That would be a huge change. I don't think it's quite coming, but they realized that there was an enforcement shortfall, a serious enforcement shortfall, and the more you know about China, you'll find out that there are bubbles and frauds there all over those markets, much more than anything that we've perceived in Europe or the United States recently. So I am someone who believes that entrepreneurial litigation can spread, but the major obstacle is probably culture and not law. You can change the law, but not the culture. What we've seen, to the extent that we have seen some entrepreneurial litigation enter Europe through the Whiteham statute and others, is we've seen American entrepreneurs structure these things. They don't appear in court, but they are behind the scenes organizing the shtick-tings, organizing litigation funders, and then they hire local counsel to go into court on an hourly basis, but they are making the large profit to the extent there is a large profit to be made. And that dates back to the Royal Dutch Shell case in 2009, where an awful lot of money was made by American lawyers in the Whiteham procedure. Okay, so far we're talking only about the commercial side of litigation. A word or two should be said about human rights litigation as well. And here, I think context counts, because while I think the US is way in advance of Europe in terms of authorizing what I'll call entrepreneurial litigation, which isn't just the contingent fee, it could be all kinds of other systems of financing, it is going to be much slower than Europe with regard to human rights litigation. Let me take you through a short tour of the law here. While you were aware of all kinds of human rights legal decisions in Europe and human rights standards, in the US it's been quite the opposite. The Supreme Court over the last 10 years has basically emasculated, cut back tremendously on the weapon that human rights activists chiefly used in the United States. It's something called the Alien Tort Statute. And in two decisions, one involving Royal Dutch Shell, where the allegations were that Royal Dutch Shell had cooperated and been complicit in the murder of a Nigerian activist in a Nigerian prison. The Supreme Court said, even if that were correct and that could be shown, it doesn't fall within the scope, as we interpret it, of the Alien Tort Statute. That's none of our business. The statute was extraterritorial, but they decided this kind of conduct didn't fall within their idea of what the Alien Tort Statute was meant to reach. Then last year, and this case may really shock you, this was a case decided 5-4 by the Supreme Court called Arab Bank. Arab Bank was active in Arab states and was used by virtually all terrorist organizations in the Middle East to funnel money between various squads and cells. And the evidence showed that they had been very much involved in channeling money to terrorist groups, and the plaintiffs were able to show deaths of, I think it was several thousand people injured or killed. And the eventual judgment was multi-billion dollars by a U.S. court against Arab Bank, and that would have been a death sentence for Arab Bank. What happened? The Supreme Court, in a 5-4 decision last year, decided that the statute did not apply to corporations. Now, this is a statute that's been around since something like 1796 or 1802, something like that. And now they decide after 200 years that it doesn't apply to corporations. Of course, in a multinational world, in a global world, it's corporations that have the money. You're not going to get personal jurisdiction and enforce something against individuals, particularly operating in a shadow operation someplace. But it's corporations that'll hold the assets, and you won't be able to sue them under this statute. That shows a very conservative U.S. approach to litigation, very different than its approach towards what I'll call entrepreneurial commercial litigation. And what's going on? I think to some degree, the U.S. doesn't want to be policeman for the world. That was clearly Scalia's position. He didn't want vague U.S. statutes to be interpreted by aggressive, ambitious courts to create worldwide standards that the U.S. would be required to enforce. It's also a matter of defense of sovereignty. The U.S. is one of the few countries that is not a member to the International Criminal Court. Russia, China, and a few dictatorships in Africa also haven't joined. But it is fear that we have to defend our troops, our soldiers, they won't join it. If there were a similar treaty establishing an international court for what? For mass torts, perhaps. And if there was some kind of treaty system that created an international court to handle mass torts, I doubt very much that the U.S. would sign it. At least the current administration and recent administrations wouldn't. And I doubt they are nervous about international standards being applied by bodies outside the U.S. that would bind individuals within the U.S. That's somewhat defensive. Scalia was very clear on this. He didn't think there was adequate accountability when groups, whether it's the European lawsuit or something else, would come up with standards that were never approved by a legislature or by the highest court in the jurisdiction. So I think you'll see the U.S. lagging behind in terms of the spread of international standards that can be enforced in the area of human rights, whereas it appears to be leading the world. The U.S. is quite ready to enforce commercial judgments. Canadian class actions get enforced in the U.S. all the time. There's been no problem about that. But I think you're going to see a day and night difference based on factors that are deeply rooted in both nations between a conservative approach to human rights enforcement and a more liberal approach, more expansive approach towards commercial enforcement. Now, I agree with Sam on one thing. I have a book called Entrepreneurial Litigation, Its Rise, Fall, and Future, Harvard University Press 2 years ago, and I chart in it the ratios between major enforcement action and major class action private enforcement following it. And you regularly find at least a 10-to-1 ratio. That is, the SEC or the Department of Justice gets X million dollars, and the private enforcers get more than 10 times, sometimes 100 times more. The private enforcers are much more motivated to go for the money because they're getting a share of it. But if you want significant damages, if your belief is that significant damages deter, private enforcement is the only way you get that number. And at least that's the U.S. experience. And I don't know that there's contrary experience where we're talking about the kind of numbers. When you look at the gross profits of the world's 100 largest corporations, all the fines that get leveled against them don't represent more than 0.5% of their total profits or their total market capitalization. So damages that really deter probably do require additional enforcement because state enforcers are always constrained by budgets, by limited staff, and by the pressure of other bad guys who also deserve to be pursued by regulators. I do think you would, if you want real enforcement, and you can debate whether real enforcement will really change behavior. I personally believe, because I also specialize in white-collar crime, that criminal enforcement against individuals has the greatest deterrent strength. But that also has its problems. Okay, so I've suggested that we're seeing the U.S. very expansive in one context, very cautious in another context, and I'm suggesting, too, that we will see growth in enforcement, but it will depend upon the incentives being set. Once the incentives are set, if the local enforcers don't want to do the enforcement, you will see now that there's a worldwide group of enforcers, including these American law firms that have gone to Europe, that will be able to bring the resources and hire the local lawyers. I think that private enforcement is the principal route that can be easily changed, but I would tell you again that I think real change probably requires more aggressive criminal enforcement against high management, high officers, and that's been very slow all around the world. So, you've heard some pessimism, you've heard some optimism, and now I'll turn it over to our panelists.
Speaking about change of atmosphere and new class actions coming in different countries. So in China, as we heard yesterday, there was a system, there is an introduction of new system of class action. And they even had a case on milk contamination, very well known, called Sanlu. And, but the problem was that dairies belonged to the government. The case ended in some compensation scheme, and the lawyer fees were not so big because the lawyer was arrested afterwards. Not because of the case, but he was jailed for a few years. This is a change of atmosphere, I think. Well, I can go on listening to you, all three of you, for hours, but we have to put an end in the end because the Sabbat is going to impose on us. And maybe you want to ask one or two questions, otherwise we'll have to close, unfortunately, this conference. Any questions? Okay.
Sold.
I really enjoyed this conference, and I hope that you also enjoyed it. For those of you who lost some of the presentation today, as I unfortunately had to do because I kept running between the two floors to hear as much as possible, don't worry, in the end we will publish it on YouTube soon. We will try to do it soon. Thank you.
And on the conference website, of course.
And on the web.
Yes.
Okay. Thank you very much. It's been an honor for us, and we hope to remain in touch. Thank you.